Hello, welcome to this webinar. My name is Gliarkos Kyriakidis. I'm an assistant professor in the School of Law of the Cyprus campus of the University of Central Lancashire, otherwise known as UCLan Cyprus. It gives me great pleasure to welcome you to this webinar. It will take the form of an online Socratic dialogue, which will be legally flavoured, business-focused and Cyprus-centred. The dialogue forms an integral part of my school's ongoing programme of executive education courses designed to assist members of the legal profession, members of other professions, members of the business community, and other people in the private or public sectors. The dialogue also interrelates with a new initiative of the School of Law of UCLan Cyprus. This initiative is called the Rule of Law Monitoring Mechanism, otherwise known as ROLM. It's a new online platform designed to monitor the application of the rule of law amid any crisis, such as the current one that we're all unfortunately experiencing. Details on the rule of law monitoring mechanism are at lawblog.uclancyprus.ac.cy. This Socratic dialogue will be founded on a question which is a reflection of the disturbing and destabilizing times we are currently immersed in. And the question is quite simple. What does the COVID-19 outbreak mean for your business? Now, needless to say, this question is a byproduct of the genesis of the coronavirus COVID-19 epidemic in late 2019 and its official metamorphosis into a pandemic, according to the World Health Organization, on the 11th of March 2020. With the pandemic very much in mind, it's appropriate for me at the very outset to pause for a moment. I'd like to convey my condolences and also those of my fellow speaker to all of the families around the world who've lost loved ones. My fellow speaker and I would also like to express our sincere gratitude to all those working in exceptionally difficult circumstances to help their fellow human beings, be they in hospitals or anywhere else. We thank you. On that somber note, let me now introduce our distinguished guest and my fellow speaker, who will indeed be the main speaker today. His name is Stylianos Christoforou. Stylianos was educated in England at the universities of Hull, Nottingham, and the Inns of Court School of Law. After being called to the bar by Gray's Inn in London, he thereafter qualified as a lawyer in the Republic of Cyprus, whose legal tradition owes much to the English one. Today, Stylianos is a distinguished barrister at law, a practicing lawyer, and the managing partner in the Stylianos and Christoforou law firm in Nicosia, which of course is the capital city of the Republic of Cyprus. Over the years, he has acquired a particular expertise in the fields of commercial law and data protection. He has also acquired, I should emphasize, a close working relationship with my university. Stylianos informs me that on a daily basis, he and the members of his team advise businesses on all legal matters, and this is precisely what his team have been doing during this exceptionally difficult time. Hence his willingness to share his experiences with us today. Now, for my part, perhaps I should emphasize or add, I'm a legal academic these days. I'm a non-practicing solicitor and thus a former practicing member of the legal profession of England and Wales. I qualified as a solicitor in 2003 and worked in private practice in London until 2007 before focusing my career on legal education, and I've been privileged to work at UCLan Cyprus since 2015. Now, before I activate my Socratic dialogue with Stylianos, I ought to stress that in this dialogue, Stylianos and I will not be offering any legal advice. Indeed, nothing we say should be interpreted as constituting advice of any sort. Instead, in an exercise of academic freedom, our primary purposes are to offer what I like to call the 3 I's: insights, interpretations, and ideas. With all that in mind, I will now begin by articulating the core question which overhangs all of the other issues to be addressed during our dialogue today. What does the COVID-19 outbreak mean for anybody who has a business, particularly in the Republic of Cyprus? For my part, all I will say in response to this critical question is something obvious. Virtually every business is now facing serious problems with multiple implications, including implications flowing from the law. By way of illustration, let me mention just 3 of these, among many I could cite. One is health and safety law, a second is employment law, and a third is business law, the latter of which is a broad area which has recently acquired fresh dimensions amid the pandemic. Stylianos, thank you for being here. In which direction would you like to steer our dialogue?
Good morning, Klearchos. Thank you very much for inviting me to initiate this discussion with you. It is always a great honor to work with UCLan University. I have to say that the past 3 weeks have been extremely important for the businesses all over the world. The pandemic has crashed on all the businesses in such a way that nobody would actually expect it to be, and has caused this era to be a force majeure one, or if you like, act of God. It is very important to understand that the businesses have suffered a great amount of financial impact. So apart from the medical profession, apart from the health issues, apart from the health and safety issues you have mentioned earlier on, the businesses as a general have suffered an impact. And I was discussing with some friends the other day, this is not to be related with the financial crisis of 2013. The reason for being that is that the financial crisis of 2013 was not global in 2013. It was initiated in 2008. It covered most of the countries by 2012. In Cyprus was affected in 2011 and onwards. So when Cyprus was in the middle of the financial crisis, the other countries were not. So in Cyprus, we also had the streaming of funds from the activities that involved foreign clientele, like the tourism and the corporate services. Now, we don't have that either. Now, at the same time, the global is in a crisis. So we have to really understand that it is not just a simple thing that will go over in a few weeks. It's something that will not last as long as the previous financial crisis lasted. However, the impact may be greater. And that is why the businesses should take the correct decisions. It is very important to make the correct decisions, and it is very important to be well informed and educated. The 3 I's, as you have mentioned. They need to take informed decisions. It is also true to say that the past 3 weeks, even though I have been working from home and I have converted my veranda into my office, I have been discussing with lots of businessmen and with and I have been trying to accommodate their worries, answer their questions, interpret the measures the Ministry of Labour has issued in order to support the businesses. And now, 3 weeks later, I am in position to share this experience I've had with you. Obviously, what we will say does not amount to a legal advice, because the legal advice has to be custom made and not a general one. But I hope that it will help businessmen steer towards the correct direction, or at least clear some of the main questions they are facing now in them trying to interpret the measures the Ministry of Labour has announced. Therefore, we have also prepared a short presentation, which
your sound.
Sorry, so that,
yes.
that must be correct. There has been a connection problem. So I am trying to share the presentation I have prepared, which I have shared with my clients in order to help them understand how these measures work, so that they have something at their hands to work with as a tool, which is this one. It is very important to understand again that these questions and answers are the result of my interaction with my clients. They do not correspond to every business. However, they will cover most of the questions any business may have. So here we go. Now, just like the title of this webinar is, what does the coronavirus outbreak means for your business? Obviously, it means a huge challenge. It's a huge challenge, financial challenge, and at some point, and for some businesses, survival challenge. The government has issued a number of schemes, measures, in order to support the businesses with two main pillars. The first one is to maintain the businesses operational. So when the outbreak is a history, they will be able to continue to work to pick up where they left it from before. The second one is the second pillar is to help the businesses not to dismiss employees, to avert, if you like, any dismissal of employees, because that would have a huge impact on the economy as a whole.
Can I just step in here briefly, Styliano? Is this a difference with the approach adopted in 2013? Because from the way I see it, the big historical difference between what we're seeing now and in 2013 is that in 2013 there was an implosion in the Cypriot economy, in part because of excessive lending and excessive borrowing, and there were multiple causes. On this occasion, there seems to be a single cause to the economic difficulties we're all in, and that is the pandemic. So would you agree with me that there is actually a structural difference between 2013 and what is being followed today?
Well, despite the reason being different for this crisis, the impact will be the same.
Yes.
So the end result is that once again, the enterprises will have to cut down on costs. Number one cost is the payroll. Therefore, the impact will be rolled over to a certain percentage to the employees and therefore to the society. Mm. Major difference, however, is the fact that now, today, we have the Ministry of Labour to support the enterprises. We have the banks who have agreed to offer, to suspend for the enterprises to suspend the loan installments. The government, which has agreed for the enterprises not to pay the VAT that they have collected, and also the banks who are discussing of providing loans to the enterprises, which will be given in a simple way and at a low interest rate. Now, we didn't have all these gifts, let's say, back in 2013. Since we have them now, I am optimistic that this crisis will last much, much shorter, and the final impact will be less severe on the financials of Cyprus. Of course, having said that, don't forget that the tourism will be affected a great deal because of this, since nobody is flying anywhere because of the coronavirus. And even when the coronavirus will be handled, still, I think people's first concern will not be to go on holidays outside the country, because they will have a certain amount of fear with regards to the potential exposure to coronavirus. So overall, I am optimistic that things will be better this time. And of course, all these measures, they help to support the cash flow of every business. And if I may say, or if I may pick it up where we left it before, the schemes of the government to support the enterprises were designed in order to upon one requirement, that any eligible enterprise will not terminate any employee for a certain period of time. So let's go and see what these measures are like. So the first measure relates to the full suspension of activities. If you recall, back in March 16, the Minister of Labour has, along with the Minister of Finance and the Minister of Health, they have announced a number of enterprises whose activities would be suspended totally. And these were restaurants, coffee shops, malls, hairdressers, now schools, universities. This group of companies whose activities were fully suspended, they are entitled they are eligible to apply for the full suspension scheme. Now, the full suspension scheme provides that any of those companies whose activities has been suspended following an order, they are entitled to claim the 75% of their employees on suspension of employment. Now, what does that mean? Now, I think I didn't say it I didn't say it very easy. I said it quite complicated. What does this scheme say, again, Klearchos, is that those companies whose activities have been suspended under an order, they're entitled to suspend the employment of their employees and benefit from this scheme. They're entitled to suspend the 90% of their employees, which means that these employees will actually apply for a payment from the unemployment fund, and the remaining 10% will continue to be paid by the enterprise. The aim of this scheme is to provide the subsidy to the payroll with regards to the 90% of the employees, and continue with the 10% of the employees. And the reason the scheme provides for a continuity of the 10% and exclusion of the scheme is in order to establish business continuity of these enterprises once things will get better. So if we're going to put this in a framework, it means that a restaurant which has been employing 10 employees and whose activities have been suspended through the order, 9 of these employees will be registered under the full suspension scheme, and 1 employee will remain to work. The reason that 1 employee will remain to work will be just for the sole purpose of keeping the business ready for the continuity after the virus is gone. What happens now with the 90%? The 90% of the employees will have to remain home. They will visit the special site designed by the Ministry of Labor, which is coronavirus.mlsi.gov.cy. Visit the relevant part of the website where they will be invited to enter their personal details and in particular their IBAN number.
Styliano, can you repeat please that website address?
It's coronavirus.mlsi.gov.cy.
Thank you very much.
The employer will also have to visit this website in order to apply for under the suspension scheme. The employer will be asked to fill in two tables. On the first table, the employer will have to fill in the name, the social insurance number, the date of birth, the years the employer has been with him, for all those employees who will enter the suspension scheme, the 90% that is. The remaining, the second table will be used for the employer to fill in the same details of the employee who will remain, the 10%. They are also asked to agree to a declaration that all the information provided are true and correct, and then they just press send and the application is over and done with. So it's a very, very easy, straightforward procedure to complete. It is very important to fill in the tables correctly, because if they don't fill in the tables correctly, or if the employees fill in their IBAN details correctly, then the application cannot be processed. So there will be a considerable amount of delay when the ministry will have to pay them. And this is the particulars of the full suspension scheme. Now, questions that we have been receiving about this scheme are the following. What happens if my enterprise, which has been included in the order, has found other ways of operating? For example, restaurants who are doing deliveries, schools who are offering online sessions. For those enterprises, the Ministry of Labor has clarified that since they have found alternative ways of operating, they will not fall under the full suspension scheme, because in effect they have not suspended their activities. However, even if they have found alternative ways of working, still they have suffered a loss of turnover, they will be eligible to apply for the partial suspension scheme, which we'll elaborate in a while. with regards to the salaries of the employees and the very, very important question as to how much money will the employee whose employment has been suspended receive from the Ministry of Labour through the unemployment fund, the answer to this question, and I have to be clear and frank at this point, is that the employee will receive the 60% of the amount of the insurable income. Now, the insurable income is not always the salary of the employee. And what do I mean by that? If an employee receives a salary of €1,000, then the 60% of the insurable income of the €1,000 is €600. However, if there's an employee who receives €1,200, but 1,000 is the salary, and the 200 is for traveling expenses as a benefit, then the insurable income is only on the €1,000. So that employee will be paid by the unemployment fund the amount of €600 only. There is a cap on this amount, which is €1,214. So the employees, irrespective of what their salary is, the maximum they can get from this scheme and from any scheme is €1,214.
That's per month, is it?
That's per month. For now, these schemes were available until 12th of April, but they have been extended until June. So these schemes will continue to be enforced until June, and any eligible enterprises may take advantage of this scheme. Another question we are receiving is how will the Ministry of Labour secure that those applications the enterprise are made are not fraudulent and what they declare is actually real, which is, for example, following an order, as a restaurant, I have decided to end the business, and I don't declare that I'm also doing deliveries and I have some gain from deliveries. The answer to that is that for now, the Ministry of Labour has said that there will not be significant checks because the aim is for the employees to be paid. However, and that relates to the business ethics of every company, these funds are not scheduled to pay any business who decided to take advantage of the scheme, but they are aimed for those who are in need. And because the business ethics is always a matter which is under interpretation and subjective at the most, I'm sure that the Ministry of Labour at some point will do checks as to the clarity of the information provided by any business when was applying for the scheme, for funding under the scheme. And I have to remind that the penalty may reach up to €40,000.
Just if I may comment there briefly, history teaches us that whenever there's any major war or catastrophe or crisis, opportunities are presented to certain people to make money legitimately, but equally opportunities are presented to people to make money illegitimately. And I suppose the message that we would like to send is that seize the opportunities to make money legitimately and do not fall foul of the criminal law through any fraudulent statements made to the authorities or any misrepresentations made to the authorities. So that's a very basic point, but it's worth remembering as the future unfolds.
This is true, and we have to be really cautious about it, because once again, those funds are not aimed for the businesses as such. They are aimed to help the businesses, to help their employees, and to help the business continuity. If any business does not need that money, they shouldn't be claiming. Now, another question that I always receive is, can employees whose work has been suspended work from home? And this is the one I'm showing under 4 on the current slide. And the answer is that employees whose work has been suspended cannot work from home for the sole reason that it has actually been suspended. The same, however, does not apply if an enterprise has fallen under the partial suspension scheme, which is the next scheme we will be discussing in a while. And here we are. Now, the partial suspension scheme, which is the scheme that most of the companies are falling under. Initially, the partial suspension scheme covered the period of March 16 until April 12. However, it has been prolonged until June. Eligible enterprises are the enterprises who had a contraction to their volume of work of more than 25% from the 16th of March onwards. At this point, I would like to remind that the first version of this measure mentioned for a contraction on the volume of work from 1st of March and onwards. But a week later, the Ministry of Labour has changed that and has corrected it, I must say, to say that the calculation for the contraction of the volume of work will be from March 16th, the day when the scheme came into, the day when the scheme began to apply and onwards. One of the major questions we receive, Klearchos, is what is the contraction of the volume of work? Despite being an accounting term, it's a term that we're quite familiar with as lawyers, because this is the term used by the Redundancy Fund when they examine applications for redundancies. So under the case law, but also under the accounting standards, the contraction of the volume of work relates very, very simply to the sales. How many sales I have done in this period? So how many sales has an enterprise done? Not how much money has collected, not how much money has earned, not how much profit has made. How many sales has that company made? So if, let's say, we are using as an example a company who is trading, let's say trading pharmaceutical products. If in March of 2019, that company has actually sold 1 million pharmaceutical products, not 1 million worth of pharmaceutical products, 1 million pharmaceutical products, and this year it has managed to sell 500,000 pharmaceutical products, that is a 50% contraction to the volume of work. If last year I have issued as a business consultant 20 invoices worth 20,000 euro, and today I am invoicing 10 invoices of 15,000 euro, that again is a contraction to the volume of work of 25%. So it's how many sales I have made, I have achieved, and not how much money I have earned, and not how much money I have managed to collect from the invoices issued in the previous months. This is very crucial for someone to understand in order to effectively calculate whether his enterprise has actually suffered more than 25% loss on the contraction of the volume of work or not.
So in practice, how important are the annual accounts and the annual tax declarations made by a business to performing that calculation and submitting a correct request to the authorities?
Well, take into consideration that we are talking about the contraction of the volume of work from March 16, 2019 to March 16, 2020 and onwards. I'm not sure that the financial accounts will help. I would expect management accounts to help better, because they may give a better idea, a better picture as to how these work.
So we've lost your voice, Stiliano.
Yes,
Can you come back?
sorry, I had to mute the microphone. One of the industries that has been asking us a lot as to whether they have suffered a contraction to their volume of work are the developers. Because the developers, they had some difficulties in calculating their volume of work for March. So we have asked the advice of some accountants who have told us that you need to take into consideration when the property has actually been sold to the developer. If the sale agreement was signed in September, that's when the sale was actually executed. Now, when the buyer will actually pay off the purchasing price to the developer, that's another issue, which somebody must not take into consideration when is calculated the contraction of the volume of work. Do you think that makes, is it clear enough? Or you believe that I need to clarify more?
I think we've understood that. I mean, I would just make a broader point. This scheme appears to fall within the general pattern we find with new legal measures. There seems to be a general principle at play, but it's subject to one or more exceptions or qualifications, and it's very difficult to understand it unless you actually sit down and read it line by line and apply it to the specific facts of your particular business.
Yes, that is also true. That is also true. That's why we're giving some guidelines in order to help businessmen to do that exercise.
Yeah. And I think what has also emerged from your discussion is that the particular demands of a restaurant may not be exactly the same as the particular demands or requirements of a hotel or a building developer or a private school or a private takeaway. Every business will have its own peculiar or particular difficulties, and those difficulties need to be woven into the application to make sure that the application stands a chance of succeeding.
That's true. That's true.
That's come across vividly from your discussion so far. Yes. So thank you.
You're welcome. You're welcome. The next important prerequisite for applying into these schemes, and now I'm referring to both schemes, the full suspension scheme and the partial suspension scheme, is the fact that the employer is not allowed to terminate the employment of any employee.
That's important.
As you said, this is the main pillar of these schemes. along with the business continuity effort. And therefore, the scheme, it provides that for a certain period of time, the employer is not allowed to terminate the employment of employees. In explaining that, I will have to tell you about how that period is calculated. I will also have to tell you the exceptions to the rule. So that period is calculated as follows. We take the duration of the period for which our enterprise has been funded by the scheme. So if, let's say, one enterprise has asked for funding only for April, it's not allowed to terminate the employment of employees as follows. For April, which is for the duration that the company is under the scheme, another equal duration as the one that has been under the scheme, so that's another month, plus 1 month. So if we're going to put that in months, we are talking about being able to terminate the employment of an employee again in July, because it's April is the period under which the company has been under the scheme, another period of time of 1 month as per the scheme, which is May, plus another month, which is June, so it goes to July. Enterprises will choose to be on the scheme until June. The calculation will be as follows. Let's say it's going to be from 1st of April until end of June, when the scheme currently expires. We're talking about 3 months almost. So for those 3 months, they will not be able to terminate the employment of an employee, plus another 3 months, which is September, plus another month, which is October. So they'll be able to terminate the employment of an employee in November. This is very, very important, because the employers, the enterprises, what they do is that they make exercises as to what is more beneficial to them. Some of them consider the following. They consider of not entering the schemes, but terminating the employment of employees on grounds of redundancy. And if they're doing that, they must be able to calculate the period under which they are not entitled to terminate the employment of employees efficiently. The exception to the rule as to who is I'm sorry, a minute. So the exception to the rule as to who is the employer allowed to terminate the employment is very important as well, and it goes as follows. The employment of any employee whose termination need not be on notice. So any employee who does not need, as per the law, notice before the termination of the employment is excluded. And in order to be less technical and more precise, this applies to the following categories of employees. First of all, the employees who are under probation. Any employee who's under a probation period is the employer allowed to terminate the employment and not affect its eligibility under the schemes. The same way, any employee who is under a fixed term contract which expires is also considered to be an exception to the rule. If I may remind, a fixed term contract is the contract that has been formed in order to cover certain occasional needs of the company, and it has a certain duration, an expiry date, that is. So if we have such an employment which falls under the fixed term contract. When the contract expires, then the employment will be terminated immediately, and that falls under the exception. The next exception to the rule are anyone who will reach the retirement age during this period. And the last one is the occasion, this is very important, it's the occasion where the employer decides to terminate the employment of an employee because the employee has showed such a behavior that has caused the breach of trust between the employer and the employee. So in other words, the employer does not have to tolerate any employee who is acting in such a way that causes the breach of trust. And I don't want to be mistaken, but behaviors that cause the breach of trust are severe behaviors like stealing, like stealing of property, stealing of data, bullying, bad behavior towards co-employees, towards the employer, sexual harassment, and of that sort. So these are the exceptions under which any employer may terminate, but still not terminate employment of employees, but still not jeopardize its eligibility under the schemes.
Mm-hmm.
Another very important question, once again, is what are the percentages of the employees who will, whose employment will be suspended, as opposed to the full suspension scheme, where the ratios were 90% and 10%. The ratios here are different. We have two categories. The first category relates to the employees who are to the enterprises who employ more than 50 employees, and the enterprises who employ less than 50 employees. The ones who employ less than 50 employees are entitled to suspend the employment of 75% of their employment force. The companies who fall under the category who employ more than 50 employees, they are entitled to suspend the employment of 60% of the employees. In choosing which employees will fall on the 25 or the 40%, or in other words, will fall on that category which does not fall under the suspension scheme, I have to note that the scheme is very precise, that in that category, we have the employees who are benefiting from other schemes, like the employees who are under the suspension already because they have been infected by the virus, or they fall under the high risk group of the society, or those employees who are home taking care of their children. Apart from that category, the next category of employees that has to fall under the 25% or the 40% are the employees who are also shareholders of the companies of more than 20%, and or directors, and then also the C positions who are the CEOs, CFOs. Those always remain in the 25 or the 40% who are not included in the suspension scheme. The suspension scheme also clears that the participants to that scheme will again receive the 60% of their insurable income, which again, insurable income relates to the 60% of the salary most times, but we're talking the salary, we're not talking about any benefits, any other benefits the employees are paid.
I think that was the first time we had
housing expenses, mobile phone expenses, and so on. Claire, I think I have lost you.
Yes, I was going to say that was the first time we seem to have an IT problem. Can you hear me now?
I can, yes.
Okay. I just wanted to warn you that we're approaching the final 10 minutes. So do you want to just bear that in mind as you conclude your analysis?
Yes. I am also concluding because I don't want to tire people. One of the questions we usually are usually asked is as to whether the employer needs the consent of the employees in order to include them in the 75 or the 60%. So in other words, whether we need to have the consent of the employees in order to include them in the scheme. The answer to that is that the employer does not need the consent. It is a management prerogative to choose which employees will include in the scheme and which employees will remain to work full-time. However, on the partial suspension scheme, the scheme itself provides the opportunity to the employers, following consent by their employees, to continue to work despite being included in the suspension scheme, provided that the employer will continue to pay the remaining 40% of their insurable income. So if I'm going to put that into practice, one employee who is included in the scheme will continue to work, and that employee will take the 60% of his salary or her salary from the unemployment fund, and the remaining 40% will be paid by the employer as a top-up, plus, of course, corresponding payment to the social insurances, which these give a great amount of flexibility to the enterprises, because on the one hand, they benefit from the fact that from the scheme and from the fact that their payroll cost is subsidized, but on the other hand, they can continue, they have the employees ready to continue to work. For that, a consent is needed by the employee, but it is a very important element of the partial suspension scheme. Closing, I would like to share my experience with regards to the employers who are really afraid of this situation and who are considering the not registering with this scheme, but choosing to terminate the employment of employees on grounds of redundancy. This is a question that I receive quite often, and the answer, the advice, if you like, I give is goes as follows. They have to be very cautious for two reasons. All these schemes have a prerequisite. Employers cannot terminate the employment of employees. So if they choose not to take advantage of the schemes because they want to actually terminate the employment of the employees on grounds of redundancy, I am sure that when time comes for that application to be examined, the redundancy fund will be very strict. The second part is that there must be redundancy reasons in order to be able to terminate the employment of an employee on ground of redundancy. One, and the most commonly used ground for redundancy, is the contraction of the volume of work. The 25% contraction of the volume of work is indeed a percentage which would excuse a redundancy. However, the law says that this contraction of the volume of work must also have the element of permanence. What does that? It means that this contraction of the volume of work must be a contraction, a percentage that has been going on for some months now, or even a year, and must be a projection that it will not get better. What we go through now is a short-term crisis, at least for now, which has caused a contraction to the volume of work, which is short-term. So if somebody chooses today to terminate the employment of an employee on the ground of the contraction of the volume of work, I am quite certain that this attempt will fail. And if that fails, then the immediate result is that this termination of employment is illegal, which has two immediate results. A, that employer cannot benefit from the schemes. B, the employer will have, the employee is eligible to compensation by the employer. And one more point is that this situation which we are facing, which is another question I very often receive, may be a force majeure situation, may be considered as an act of God. However, it is not a situation that fulfills the criteria to claim that I will terminate the employment of employees because it's force majeure, because it's act of God. The reason being is that even though it may be force majeure, it has to be directly related to the employment. And even though at some times it is directly related in the sense that I cannot sell, still one will have to answer the question, yes, but the government has issued the full suspension scheme, the partial suspension scheme. The government is not, has allowed you not to pay the VAT, to contribute the VAT. The government has also reached an agreement with the banks, so they will not, they will allow you to suspend the payment of the monthly installments. So even though we are in a force majeure situation, potentially, still you have way out from that. So that will not also work as a valid ground for the termination of the employment of employees. So I think pretty much that's all I had to cover, Klearchos, for you from our experience. I hope I have provided an overview and some info as to what businessmen should know, should have in mind during this very, very challenging period of time that we're going through. If you have any questions, I'll be happy to answer.
Would you like to put the slide on the screen that has your email address? Because if anybody wants to follow up with any particular questions, perhaps they can email you. If that's with your consent, of course. There it is. Yeah.
Yes. So this is our email address. If anyone would like to send us an email, or we can share this presentation with them, which gives a lot of answers. Obviously, we didn't manage to cover the whole of it, but we have covered the most important parts of it. We'll be happy to share it with them in order to assist them with anything they may need.
I just have one final question, if I may. I know you're an expert in GDPR. Could you offer us an insight or two into the potential dangers that businesses have been exposed to in the context of GDPR? In other words, how has the pandemic affected the duties and the risks of firms and businesses in the context of GDPR?
Yes.
Data protection, of course.
Yes. Thank you for calling me an expert, Glerhos. I don't think I'm an expert. I think I may have some more experience on the matter, but not an expert indeed. But thank you for that. In any event, the GDPR, which relates to data protection, of course, has kicked in more severely than we expected because of this situation. The reason for that is because we have, from out of the clear blue sky, we had to start working remotely. We became more digital from one day to another. Before the coronavirus, we would wake up in the morning, go to our offices, work there. Now, we work from home, which means that we have everything at home. And that brings up two issues: the digital part and the paper part. The digital part relates to the fact that through the cloud providers, we are working from home, we are exchanging emails, we produce from the PCs while at home. We're having meetings just like this one. So we are more digital. And when one is more digital, always bears the risk of data breach. This data breach may come in different sorts. It may be because a hacker is following or has attacked our network, or it may be because a member of the family is observing what we're discussing or what we're exchanging, or because because we are working somewhere where others may listen to what we are actually saying. All this information that we are losing without us knowing are considered to be data breach, and potentially they become harmful. So our suggestion is that, first of all employees who work from home should make sure that they connect through a safe connection with the servers or their clouds. They should, of course, always use their own Wi-Fi network, which must be protected adequately through a password, which obviously will not be 1, 2, 3, 4. It is important for that password to be changed. I would suggest every 15 days. It is very important to keep all their work safe. Always log out from the PC they use, because others may also be using it from their families. Not share the content of their work with members of their family. I do understand that we are all locked into the same room, into the same house, and we may be running out of topics for conversation. But trust me, your employment is not for discussion, even under these circumstances. It will be considered as a data breach. And for those of us, I'm talking about the lawyers, who also need to carry files at home, and apart from the lawyers, it could be also accountants, architects, designers, any profession that needs to carry files, papers at home. They must also be very careful as to what they do with that paper during transportation. They have to make sure they will not lose it. They have to make sure that no piece of paper, they drop piece of papers on the way from their car to their house. They may have to make sure that they destroy all the notes they make or the paper they don't need. And destroy does not mean I am throwing at the dustbin. Destroy means I actually destroy it. If they don't have the means to destroy it, they can send it back to their offices where they would be destroyed there. And generally speaking, we have to be a bit more cautious, just a bit more cautious, because of the data protection.
That's a good note to close on, Stiliano. I'd like to thank you on behalf of the university and the many people who will be observing this video Thank you for giving us such a vivid insight into the range of legal and business issues that have emerged from the coronavirus pandemic and its implications in the Republic of Cyprus. I hope that sooner or later I'll be able to chair a live seminar in your presence, but in the meantime, we've had to do this remotely over the internet, and it's been a pleasure engaging in a discussion with you, Stylianos. Thank you very much. And
Klerkos, thank you very much for inviting me. I'm looking forward to having a live presentation on a more interesting topic. Until then, stay safe, and best regards to everybody at Euclid University.
Thank you, and happy Easter to you and to everyone else.
Happy
Goodbye.
Easter. Thank you very much.